Yes. I'm from Kiev.
Very good. You know, I know these letters a little bit. Not enough, but a little bit.
Hello, my name is Diana. I'm from Kazakhstan, Astana. I'm a journalist and I'm head of NGO, Legal Media Center. Our main activity is legal protection, supporting and consulting.
Hello, my name is Olena. I'm from Kiev. I'm a lawyer.
Hello, my name is Alena. I'm studying here in Kiev and live also here in law faculty and in the Institute of Journalism in Kiev National University.
Okay, great. I should mention I'm also a lawyer. Maybe you can guess on the name of the organization. We're mostly lawyers there. Okay, so we're talking about access to public information. And just in terms of style, I guess different people have different styles in this course. I would like to have a presentation because it's easier to go through and things. But I would like to have informal kind of style. So anytime you want to comment or you have a question or whatever, just put up your hand. And if I don't see you, make some noise, and because I want it to be interactive kind of style, not for me to talk for 1.5 hours. Okay, so we're talking about access to public information, and I want to start by asking you, what do you understand by that concept? What are we actually talking about for this session? And I'm not going to let you get away with being silent. By the way, I will insist that you answer. And it's not actually a difficult question either. Don't be shy.
Maybe how to get information. What's about information? How to get information at first, and what is the public information, and why it is important for us and for journalists.
Okay, yeah, those are parts of it. Other people? Yes? Yeah, sorry, we have to do that because of
This person can get public information in order to control power in a state and to take part in as a citizen of a state.
Okay, so you're starting to talk about some of the benefits. Yeah.
Я это понимаю информации, которая имеет отношение к деятельности государственных органов, местного самоуправления, то есть именно непосредственно не только журналистов, допуск до этой информации получения, но и обычных граждан. Но это именно касается информации, связанной с государством, его институтами, его органами и органами местного самоуправления, власти.
Okay, very good. Anyone else want to add? I mean, all of these are correct. Okay, so let's see if So, basically, I mean, I think that you had a good description. The core of this idea is the right to access information held by public bodies. We'll discuss later what we mean by information, what we mean by public bodies. All of these are kind of complicated. Actually, in my opinion, the concept of information is not that complicated. But I just listened to 40 minutes presentation by a very senior judge here in Ukraine, on and on and on the definition of information, which made me wonder how a public body can possibly understand it, even though a judge cannot maybe understand it that easily. And we have kind of two core ways of accessing the information, and we'll be looking at both of those. First way is you request and you receive the information, so you can go to any public body, ask for information, and you should get it. That's at the core of it. And the other one is that the public body should push out, should proactively publish a lot of information of public importance. You shouldn't, if it's obvious somebody's going to ask for it, you should publish it before they ask for it. That's more efficient, and then everyone can get it equal access. So these are the two, let's say, ways in which we can access information. And the core here is that and it's obvious in a way if you think about it from a democratic perspective. The core idea here is that public bodies have certain information, but they don't own that information. They don't own it any more than they own the desk or the computer where they work. The computer that sits, is this a public university?
Yep.
Yeah, okay. This computer belongs to the people of Ukraine. Okay, it's owned by a public institution, and it belongs to the people, and nobody has a right to take this home and keep it. And the same thing with information. The public bodies exist to serve the people. We vote the government. We give the government a mandate through elections, and the government serves us through that mandate. It collects information, it uses information. All of that is to serve us through the mandate that we give it. Furthermore, it's operating with our money. We pay for the government. Either we pay with our taxes, or the government collects customs, or however it gets it. It's all in the name of the people, and the information belongs to the people. It's kind of a simple idea. And in a way, you could ask, why is it that it took so long, and we're going to look a little bit at that in a minute, why is it took so long for it to become widely accepted, this idea? Because it's more recent than you might think. But that's the core idea. But it's important to realize when we're thinking about this issue, that this idea, as simple and obvious and democratic as it sounds, it is a complete reversal, an absolute 180-degree turn for almost all public bodies when the first time the Right to Information Law is adopted. Before the Right to Information Law, in almost every country, even in democracies, and especially in transitional democracies, before the adoption of that law, the default assumption was none of the information, or almost none of the information, is public. Most of it we don't give to the public. Yes, some small parts of information we're going to give to the public. And then one day, this law gets adopted, and all of a sudden, the whole thing is completely reversed, at least in law. So it is a very major and radical change. I think if you, in your life, you are working along, you know, as an official, and you're keeping all of your information, you control it, you don't have to share with anyone, maybe with your boss, but definitely not with the public. And then one day, all of a sudden, somebody tells you, oh no, everything's going to change now. Now you've got to give all the information. You have to share it with everyone. You don't control it anymore. Okay, it's a huge change for officials. And because of that change, and it's a change which officials, generally speaking, don't like. They used to control information, and now they don't control information. So it's rather difficult for them to go through this change. So what we see in most countries is quite a bit of resistance from the bureaucracy. The bureaucrats, they don't like this law, generally speaking. Of course, you know, some of them like it more, and some of them like it less, and whatever. My wife is a civil servant in Canada, and I choose her to be very open, and she's okay with that. But generally speaking, it's a change that's not in the favor, you can say, or to the benefit of public officials. Okay, so that's kind of right to information as we generally have understood it. It's important also to mention a new kind of movement, which those of us who work on right to information, and I call it right to information because it is a human right. Some other terms that have traditionally been used are access to information. So in Canada, in my country, it's called the access to information law, not the right to information law. In some countries, it's called the freedom of information law. It's kind of a confusing term, but that's often used. Anyway, the new development that's been happening recently is the open government or open data movement. Probably you heard a little bit about it. And it's very closely related to access to information. The right to information advocates, like myself, we see it as the development of that concept. Some of the open data people see it as a new and wonderful thing. And basically, this movement is about accessing data sets, what we might call structured information. So typically, for example, information in Excel sheets, databases, information in rows and columns as opposed to information in text like that. There are a few aspects to it that the information should be released in machine processable forms. So rather than getting information, for example, in a PDF, in a fixed format that you can't use, you should be able to get it in Excel or in Word or in a format that you can manipulate and use. You should be able to get it for free. So historically, governments used to often charge for those kinds of data set information. Just to give a very clear example, in England, the government produces very detailed, what they call ordnance survey maps. They're maps where, 1 kilometer is about 3 centimeters square. Okay, so very detailed maps. And you could buy them. You could go to the store and buy a physical one. If you pay a lot of money, you could buy an electronic one. And historically, they sold that information. And everybody thought that was fine. With the open data movement, now the idea is that that information should be given for free. And an important driver for that is the idea that if you charge for it, very few people are going to buy it, and therefore very few people will be able to use it. If you give it for free, even though it costs you, of course, money to produce it, you give it for free, and all kinds of people will take this information and use it in weird and wonderful ways. They'll create new apps for your mobile phone. There's all kinds of interesting things that people do with this open data. So it's for free and also open for free use. You can use it however you want. And so people use a lot of commercial benefits to that. Okay. Any comments or questions? Right. Okay, so if we look back for the last 20 years and ask what's happened on this issue, now going back to the core concept of the right to information, right to access information, held by public bodies, that's always our concept. We can say that there has been more or less a revolution. I mean, a revolution is a strong term, but I think it's a reasonable term to apply to this area. A revolution in the access to information, right to information space. If we look at the number of laws, 20 years ago, only 14 countries had these laws, all of them pretty much in the West. Today, nearly 100 countries, we're 99, and one country has passed the law but hasn't quite finalized into law. It has to be signed by the president, but we've read basically at 100 laws. That's a huge growth in a period of 20 years. I don't think you can find any other area of human rights where such a dramatic growth has taken place over such a short period of time. That's a major thing. The rate of adoption of these laws until around 1997, they were being adopted very slowly, about 1 per year, let's say, and after that, up to 4 per year. The quality of the laws, and we're going to come back to these things, the quality of the laws has improved very significantly from an average, and I'm going to explain what these scores mean later, but just for now to say it, an average score of 76 in 1995 to an average score of 99, it's an increase of about 33% in equality over that period of time. Not only are these laws being adopted by governments, by states, but they're also being adopted by international financial institutions. The World Bank, for example, adopted an access to information policy starting in 1994. Now all of the international financial institutions have them. The civil society movement around this right has absolutely blossomed. In 20 years ago, in 1994, there were no, I would say there were no civil society groups working internationally on this right. you had a few groups in those countries which had laws which looked at it from their own national perspective. So in Canada, the United States, whatever. But no groups working international. Now there's a huge international movement. And there are, in every country which has a law, there's groups working on it. In those countries who don't have a law, there are groups working to get the law. I mean, there's a massive growth in civil society. Parallel movements, so in line, sort of running alongside of this core right to information movement. You have parallel movements, the International Aid Transparency Initiative, Publish What You Fund, Extractive Industries Transparency Initiative. These are openness movements about donor aid, about extractive industries, open government partnership. How many of you have heard of the open government partnership? No? You're supposed to be human rights, international human rights people. Okay, the open government partnership is it was started by President Obama of the United States and President Rousseff of Brazil, and it's a club of countries which are more open, but not perfectly open, that make a commitment by joining this club to become even much more open than that. So it's kind of a club of semi-open countries. Is Ukraine eligible for that? Yes, eligible, but hasn't joined. Oh, you joined it? Yeah, okay. There you go. I should know that. So Ukraine is a member, and it involves certain commitments about becoming more open. And also, very importantly, in the last 20 years, it has been recognized as a human right. Now, I want you to tell me honestly, if I asked you at the beginning of this, whether you thought this access to information held by public bodies, if I asked you, did you think that's a human right or not? How many of you would have said, yes, you think it's a human right? Some of you. Yes, okay. Well, it is a human right, but 20 years ago, nobody, not nobody, but almost nobody thought it was a human right. So the fact that many of you think it's a human right now, of course, you're right, but there's really been a huge change in terms of that as you know. All right. So here is the chronological development. It's just a little map. I told you we went from 14 to 100. This is the chart to show that, and you can see, does this have a pointer? No. Sorry, that's not what I'm supposed to do. Okay, well, you can see here, very, very slow, and then suddenly it took off. And it's continued like that. At the end there, it looked like it's sloping off, but it's not. That's because each of these are 2 years, but that one's only 1 year. So it's not fair. So that's the map of growth of these laws. This is the breakdown of adoption of the laws by region. Okay, so I mentioned to you that in the past it's pretty much only Western countries that had these laws. Does anybody, there was one country that's not a Western country that adopted one of these laws early on. Does anybody know what it is? No, Sweden's a Western country. Normally speaking, we consider Sweden. It's a little bit north, but still Western. Georgia? Okay, it's good to see that people is proud of their country. Denmark, also Western countries. I know these countries very north. What's that? Netherlands, also Western countries. Canada, Australia, all those countries. You'll never guess. It was Colombia in Latin America. Unusual case. And you see, this is it. Okay, it was adopted in 1985, 1980, still 1990. Oh, still only one there, maybe two at this point. Okay, so what you can see, mostly Western to start with. Around 1995, we can see Eastern and Central Europe taking off. So basically your region, and also Asia started to adopt laws in 1995. Approximately 5 years later, in 2000, we can see Latin America taking off and Africa taking off. And then, of course, Middle East and North Africa, or the Arab world, starting much later. And if we look at this is the number of wars, but if we look at the coverage of the areas, so the developed world is almost covered, except one country. Again, you want to guess which country, which Western country does not have an access to information law? USA. USA. Oh, okay, we like to criticize. I'm Canadian. We love to criticize the United States, but unfortunately, we cannot understand. Britannia. Well, you're right that Britain was very, very late. Britain adopted a law only in 2000. Okay, for Western country, very, very late, and only implemented in 2005, which is ridiculous. But it does have a law. Luxembourg, which is, of course, not an important country, but still should have a law. Okay, and East and Central Europe also almost completely covered. And this one, I want you to guess it. I think there's only one country in that region that doesn't have, not including Central Asia. In Central Asia, also some countries don't have it. But in East and Central Europe, which is the country that doesn't have it? No, actually, yeah, Belarus. Unfortunately, Belarus, not doing very well on human rights. Belarus doesn't have it. Tajikistan. In Kazakhstan? Oh, I think people have.
I know.
Well, okay, I'm going to look at my computer then. I think you may be right. Anyway, in these other regions, so Latin America, about 2/3 of the countries have laws, and 1/3 not yet. In Asia, about 1/2 of the countries, including, perhaps it will surprise you, including China. China has access to information. Can you think why China has one of these laws? It doesn't. China is not like a very democratic country, not open country. So why does China have laws? Do you think of some reason? Yes. So continue with that, thinking what particular economical issue?
Basically, they are trading with foreign partners, and maybe they need some information for foreign corporations and companies.
Okay. Yeah, sorry, go ahead.
Хотел спросить, а вообще можем просто и выиграть? Я говорю, может быть, потому что просто он интегрирован тоже в экономически и промышленно, как бы, ну,
Он не понимает,
It's not turned on. Mine.
Включи работу. Спасибо. Ну, Китай тоже интегрировал международную систему, он экономически и промышленно, очевидно, с этим тоже такие мнения пришли, что они только пытаются. Ну и может быть еще все, что Китай у них странная система эффективности, как бы. Взаимодействие с средним народом, может быть, она не совсем демократическая, но эффективная в экономическом, техническом, может быть, смысле это повлияло.
Well, you guys are very charitable and kind to China. It didn't have any free media, it doesn't have any free election, they don't have any of those things to trade with the West and to do whatever. But it's because of corruption. Okay? The Chinese are absolutely freaked out by the idea that corruption will destroy their economy. And they have huge, great economic growth, and corruption is massive in China, and so they adopted access to information in ways to combat that. And then if we look at Africa and the Arab world, only about 20% of the countries have adopted. So in those countries, still a very long way to go. Okay, so you have studied freedom of expression, right? International standards on freedom of expression during this course, you studied that? Yeah. Okay, so we mentioned that right to information is a human right, and it's a human right guaranteed as part of freedom of expression. From what you learned about freedom of expression, and from what you know about freedom of expression, when we think about freedom of expression, we think about right to speak. That's different from access to information held by public bodies. Can you think of some way in which, from a jurisprudential, from a legal theory perspective, they found the right to information inside of freedom of expression? It's a slightly tricky question, but I'm asking a lot of difficult questions because I want you to think hard.
Maybe this information needed for journalist work?
Yeah, okay, that's very good. Sorry about the microphone there.
Maybe this public information is needed for journalist work and their articles in future.
Okay, that's a good theory. You can pass it back. Journalists need to access information to do their work. Is this asking for that? This, you know when they do this, one. You know where they do this?
Yeah.
Like in the UN and stuff like that. We're very informed.
If you look at Article 10 of the European right, we can see that it's not different. Everyone has a right to get information, to get, to share, to analyze information, and once more, everyone has a right to get information. So we can make a conclusion that it's the right of everyone to get information, especially information about activity of public bodies.
Okay, very good. That essentially is right. Did you want to still add? Yeah.
I want to add that public expression is like a right to have its opinion, to have some opinion, and it's necessary for some public discussion. And in the frames of this right, we often speak about public interest. So, in order to protect its interests, people must know, like, transparently what is happening in the state.
Okay, so all of those are correct. And this is not from Article 10, it's from the Universal Declaration of Human Rights, but we can say it's not that different. I think in Article 8 it says to in part and receive and in part. So you're right about receiving information and ideas. So when this article was drafted, this one, in 1948, okay, just before the European Convention in 1951, nobody, when they drafted this, was thinking about access to information held by public bodies. No one. There were around 3 countries in the world, not even the United States, I think maybe only 2 countries, Sweden and Finland, that had access to information laws. But still, they were thinking very, I would say, forward-looking way when they drafted this. And they understood that, of course, freedom of expression is about speaking, freedom to speak. Government cannot, imprison you or control you on what you say. That's absolutely a core part of freedom of expression. But freedom of expression is more than that. It also is the right of the listener. Right of the listener to receive information and ideas. And if we look at a number of systems of regulation of free speech, for example, we can see this being manifested. And I'm going to come back to that in a second, but of course we know that freedom of expression is not an absolute right. It may be restricted under certain conditions. Article 10.2 of the European Convention, so Article 23 of the Universal Declaration also sets down the test for restrictions, and that's also true of access to information. For example, in my country, all of my medical information is held by a public body because we have a public healthcare system. So the hospital, the doctor, everything is a public body. So you cannot go and ask and get that information. It's my private information. Some information is sensitive for national security, and so on and so forth. So not all of the information that can be open. So already I mentioned seek and receive, and not just the speaker, but also the listener. And another aspect of freedom of expression, probably you already discussed it, I don't know, is not just a negative right. So Negative in the sense that the state should not interfere. That's called the negative aspect. It stops the state from interfering. I can speak and the state cannot do something. Cannot put me in prison, cannot grab me and whatever, cannot fine me, whatever. But there's also positive aspects to the right to freedom of expression. It means that the state must do something to guarantee freedom of expression. And a very good example of that, I don't know if you have looked at the issue of broadcast regulation. Have you studied that already? Some parts of it. Okay, so under international law, states are required, when they regulate broadcasting, to create an environment of diversity. Not just one person controlling all the TV, like in Italy with Berlusconi. Okay, that's not okay under international law. It must be different types of broadcasters, different kind of content, so that the viewer and the listener will receive a diversity of ideas through broadcast. This idea of the listener is not just to receive one viewpoint, but to receive a diversity of viewpoints. And this is a positive obligation of the state. State is not just saying, okay, broadcaster, go and free and do whatever you like, and if somebody buys all the TVs, it's okay. That's like, they have to make sure that doesn't happen. They have to regulate it to prevent that kind of problem. So it's a positive obligation on states. And if you think about all of these ideas together, and I don't know whether you have discussed this previously, but the right to freedom of expression under international law really is about protecting the free flow of information and ideas in society. We have information and ideas are generated and flow around in society in all kinds of complex ways, and the guarantee of freedom of expression is about protecting that richness of the free flow of ideas and information. It's something bigger than just protecting the right to speak. It's this environment of free information. There's diverse, rich, something like that. And if you look at it from that perspective, of course, we need to have a right to access the information held by public bodies, because they hold tremendous amount of useful and important information, and if we cannot access that, the free flow of information and ideas is going to be much less. That's a big information space which needs to be opened up to everybody. Does that make sense? Anybody want to comment on this different idea about freedom of expression, not just protecting the speaker, but protecting information space? Does it seem like a good way of looking at it? Okay. But this, this is very different than in many constitutions, especially earlier constitutions. So if you look, for example, at the American Constitution, which we Canadians always like to say is not as good as our Constitution. If you look at the American Constitution, the guarantee of freedom of expression, I don't know if you know it. Does anybody know it? What does it say? Yeah, the First Amendment, what does it say?
Первая поправка, которая говорит о том, что законодательный орган не имеет права вмешиваться, ограничивать, да. Никаким образом, свобода полная для выражения взглядов. Ну, мы теперь можем подразумевать, что, наверное, получение информации, это нам об этом не говорится.
So you're right when you say that it says that Congress shall pass no law restricting the freedom of speech. Congress cannot pass any law. Actually, the courts have interpreted it to allow Congress to pass law because they have a defamation law, obscenity law. I mean, you need to have laws restricting free speech, and the United States also have it. But if you look at it, it's entirely negative. It's saying to the state, stay out of this business. Don't pass any law restricting free speech. I want to speak, I want to own every newspaper, I want to own every TV. Don't pass any law stopping me. So it is, although at the time, 200 years ago, it was kind of progressive, But in the modern world, it's much less rich idea of free speech than this one about protecting the free flow of information and ideas in society. Under the European Convention, they will say not only you may pass a law, but you must pass a law. You must pass a law, for example, to regulate broadcasting, to make sure that it's diverse and rich, as we discussed. So this idea about only negative is kind of old right. Okay. Now, what may surprise you is how recent the recognition of the right to information under international law was. I don't know the exact dates, but I think that many of your constitutions from your different countries, many of those constitutions recognize access to information as a human right long time before, under international law, it was recognized. Oh, I don't have those dates on there. Oh, I think this is the wrong one. Well, okay. Okay, so I did an updated slide, but it's not good. Okay, so the special mandates on freedom of expression. There are. Have you heard of them yet? Anybody mention them in this course?
Yeah.
Yes. The special rapporteur.
Yes.
UN special rapporteur. So there's one of the UN, one of the OSCE, one in Africa, and one in the Americas. 4 of them. They were the first people to make official kind of statement about access to information as a human right. And the first time they did it was in 1999. 1999. Okay? Not that long ago. And that was just them making a statement. Then the Inter-American system had some developments in Europe. In Europe, there was a recommendation on access to information. Do you know about it? No? Okay, this was in 2002, but it's just a recommendation, it's not a binding thing. Then there was a convention in 2008. Again, well, it's binding if you ratify it, but you're not required to ratify it. So far, this convention is not even enforced yet. So none of this is binding. The first binding decision, court decision on access to information was from the Inter-American Court of Human Rights in 2006. Now, what's interesting about this? Okay, we like to think of the European as being very advanced on human rights, and generally speaking, if you look at human rights developments globally, most of the time, the European Court of Human Rights is leading. They're leading on all kinds of privacy, freedom of expression, whatever it is. That's normally the case. The first case on access to information to go to the European Court, and part of the reason the European Court is leading on this is that the people of Europe are pushing cases, hundreds of cases all the time, testing everything, pushing the court to recognize human rights. The first case on access to information that went to the European Court of Human Rights was in 1985. Okay, long time ago. 25 years ago. 30 years ago. Nearly 30 years ago. So, and in that case, European Court rejected that the right to receive and impart information under Article 10 included a right to information. They said, no, that's not what it's about. They said the right to receive information is the right between us. If I want to share some information with you, you have the right to receive it from me. Between private parties. That's your right to receive. Very small idea of the right to receive. From 1985 to 2006, when this case was decided, a dozen cases, 10 cases or something went to the European Court, Europeans pushing for stronger recognition, and every time the European Court said no. No, not about that. No, not about that. Sometimes they did give access to information as an aspect of privacy or family life. So somebody asked for information about they had been adopted, and they had been in family care, and they wanted to know about their history. So the European Court said, yes, you can get the information as part of your private life, but not as part of freedom of expression. In 2006, the case went from Chile to the Inter-American Court of Human Rights, and the Inter-American Court of Human Rights absolutely recognized it. They said, yes, this is the key part of freedom of expression. Not only that, but the states have to pass a law, they have to put in place institutional structures, they have to train its officials. They very detailed, very strong and clear recognition. Then, European Court of Human Rights started to feel a little bit like it's getting behind, and in 2009, a case went to the European Court, and this is significant. The case was from Hungary. Not from Britain, not from Sweden, not from France, from Hungary. And in the case, the European Court had never recognized the right to information. They had always refused to recognize it. In that case, the Hungarian government didn't even argue that it wasn't a right. They didn't say, no, this right is not protected. They said, yes, the right is protected. The Hungarian government was already ahead of the European Court of Human Rights. What they argued was, yes, it's a right, but under the scope of restrictions, we're allowed to refuse to give it. So they argued under Article 10.2 that they were allowed to refuse the information because it was protected information. That was the argument of the Hungarian court. So the European court found itself faced with a case in which even the state that was being brought before it was not arguing that this was not right. So pretty much they had to recognize this. What I think is interesting about this is that you have the first decision coming out of Latin America, not out of Western Europe, and the second decision basically coming out of Central Europe, again, not being driven by Western Europe. In the West, we were the first countries to pass these laws. Yes, we were, that's true. But when we passed them, when our governments passed them, they saw them as governance reforms. They saw them as a way to improve the relationship between the people and the citizens, to make government more effective, better government kind of thing, you know, not as a human right. It was coming from countries in the South and countries in the East where you had experienced the oppression of government and the way that secrecy could be used to absolutely deny democracy and to deny your basic rights. And people in this part of the world and in the South, they understood this is not just governance, this is a fundamental human right. We need this information to control our government, to defend our democracy, and to defend our human rights. And that driver, that conception of it as a human right, came not from the West. It came from Europe and not from us. So I think that's kind of interesting. Anybody want to comment on that? Come on. I need some help with all. I'm doing all the talking in the work. Yes.
Ну, я правильно понял, что вам тоже интересно с нами общаться, потому что от нас исходят идеи, которые у вас не заходят. Так много. И что вам хорошо живется с вашим правительством, не отключивайте своих граждан. Будете живы, а ваше правительство. У нас свежие идеи по этому поводу.
Well, yes, of course, it's true that we have less problem and oppression from our government. But don't believe that our government is so nice like that. I mean, you all read about the Snowden regulations and the spying of the U.S. government on the citizens, and my government is absolutely doing the same thing. But it's true. This is why it came from your side and not from ours. Okay. All right. Now, I mentioned to you before about how the laws are getting better and better. And the way we know it is that we have developed, my organization, working with another organization that's based in Europe, has developed what we call the RTI rating, Right to Information rating. And it's a methodology for assessing the quality of the legal framework for the right to information. Just the legal framework, okay? It doesn't look at implementation. It's only about the quality of the legal guarantees. And you can see, well, let me read through them so that they get translated. It's broken down into 7 categories. The right of access, for example, you have a constitutional guarantee. Scope, how wide is this law? Requesting procedures, how good are the procedures for making requests? Exceptions and refusals, are the exceptions narrow or too broad? Appeals, what happened if the public body refused? You have a nice system to appeal or not? Sanctions and protections, so this is for, are we going to protect civil servants that give information? And promotional measures, some other promotional measures for guaranteeing the right. And as you can see, in here in the middle, these 4, they all get 30 points. They're really the heart of an access to information law, and they're each receiving 30 points, and then the other ones are receiving less points for a total score of 150 points. Now, I didn't manage to put all of the countries, but I guess many of you will be interested. Ukraine actually has a very, very strong access to information law. As you can see, it's getting 115 points out of 150. This is the total maximum, and it's getting 115. That puts it, out of the 100 laws internationally, that puts it in 9th place. And Azerbaijan is equal to Ukraine in that position. And the top country, well, you want to guess what the top country is? You'll never guess it much. Which country do you think comes top on this? It's a surprising one. Nobody? Come on, guess. It's free to guess. That's a good guess. Not quite. Sweden, but that's a good guess. But actually, Sweden law is not that good. It's the oldest law, and the practice is excellent. But the law of Sweden is not that good. Finland actually is a very good law, one of the strongest in Western Europe, but not the top. Iceland.
Denmark?
No. Actually, Denmark is very poor law. we had an interesting situation that the Danes were amending their law, introducing some changes, and the media in Denmark was fighting about that. They didn't like the changes. So they asked us to analyze the changes. So, and I met with a journalist from Denmark, and he translated their draft law and all this kind of stuff, asked us if we can do that. So I said, well, I'm not just going to analyze the changes, I said, because you have a very bad law. I want to analyze the whole law. And he said, very good, even better. And we analyzed the law, and it did very poorly, and they had a huge, they carried the story from our organization for about 5 or 6 days, and we were getting telephone calls every day from different journalists in Denmark. You cannot talk to Toby Mendel when I wrote this Danish law. No, the top country is Serbia. Serbia, I know, it may be surprising. They have an excellent law, and their law is getting 135 points. So when we did the assessment and we saw Serbia getting 145 points, we were very pleased because, sometimes, I've watched that work for NGOs, sometimes NGOs want to put unreasonably high standards. They want to ask for too much. But out of 150, if some country is getting 135, for us that means that it's very reasonable rating, you can do really well. And the next 2 countries are tied, India and Slovenia. Slovenia again. All of these countries from former Yugoslavia have really good laws. That's surprising. India and Slovenia. India also probably not a country that you would think would be up high like that, but it is. And you will have, I think, a presentation, I don't know, tomorrow or the next day, excuse me, from the, you had it already from Natasha? Yes. She came? Yes. Tomorrow. So she is the information commissioner of Slovenia. Second best law. Okay. So, but if you look at Ukraine, the area where it does worse is on appeals. Okay, because the appeals don't go to really independent body, they go to the ombudsman, who's not properly independent. and the ombudsman doesn't have enough powers to deal with the complaints, proper powers to deal with, so not too good there, and not too good on promotional measures. All right. And this is the distribution of all of the scores, divided into 10-point ranges. And what you can see is that it's basically a bell curve. You know what a bell curve is? No? You guys study mathematics at all? When I was a kid, we studied mathematics. I knew about these things. A bell curve is what they call, this is not a perfect bell curve, but a bell curve is what they call a normal distribution. Basically, anything that's ordinary will distribute in a curve that looks like a bell. Most people, if you look at intelligence, okay, for example, most people is in the middle. Some people are very stupid, and some people is very smart, okay, but most people is in the middle. So if you look at intelligence in any society, it will distribute in like a bell. You know what a bell? Yeah. And if you look at wealth, if you look at whatever in society, it usually distributes on a bell curve, and it's called a normal distribution. And when you go back and study mathematics, I used to be a mathematics teacher. So this is a bell curve, normal distribution. And I mentioned before about the increase in the quality of the laws. So you can see here the laws are getting better and better and better over time. And this is my organization, this is the other organization that developed this, RTI. Okay. So I'm noticing that the time is moving on. I'm going to speed up a little bit. So what is driving this revolution in information? Why are all these countries adopting all of these things? I mean, it's really a big thing. So why is it happening? And I have a few explanations. Firstly, I think the idea of access to information is a very natural idea. It seems, as soon as you say it to somebody, if the person never thought about it, then they don't think about it. But as soon as you go to any country, even a country which is not undemocratic government, and you say to you meet somebody and you say to them, you know, you should be able to access the information held by your government. That's not their information, it's your information. As soon as you say that, that's what. It's a very natural idea. And I can say that as a human rights campaigner, my organization advocates for human rights. We have been able to start a campaign on access to information. You go in, it's like throwing a match to straw. You put the idea and somebody grabs it and runs. It's so easy to start a campaign for right to information. You want to start a campaign to reform the defamation laws. Maybe the defamation, did you study defamation in this course? Yes. So in most countries, in all of your countries, defamation laws are not good. No, I'm telling you. Even in my country, not that good. So you want to start a campaign to reform the defamation laws. It's very difficult. You have to talk, and then, oh, well, whatever. But right to information is very easy. Another idea is that I think that our expectations around participation over generations have increased enormously. If I think about my parents, pretty much they were happy to vote in the election every 4 years. They vote, that's nice, they choose the government, and then they forget it. No, really, and in that generation, people didn't participate too much. In my generation, maybe which is a little bit older than your generation, not much older, just a little bit. In my generation, we want more than that. We want to participate in the school board, to make sure they do a nice job with our kids. We want to participate in, like for example, in my area, they're building a road nearby to my house. I want to make sure that this road is okay, it's not going to annoy me, and whatever. I go into meetings, and so on and so forth. I mean, we want to participate more. And your generation, you want to participate even more than that. I mean, you want to participate in everything. I mean, really. So expectations around participation have increased a lot. I think that that's just people expect to control their life in more and more ways, which is good. Changing relations with information. Information technology have completely, totally changed our relationship with information. I mean, now we can access a million times more. When I grew up, I had hardly any access to information. You have a ton of access, totally changed. And so as we become more used to being able to access it, go online, and we can get everything, and the government's going to hide the information from us? No way. I mean, our attitude about information is different. When I grew up, information was hard to get, and you didn't even think about government information. Globalization, also a big thing. Now, wherever you live, if you live in Iran, okay, even it's a closed, undemocratic country, but you know exactly what people in Canada have voted. You go online and find out about all the democratic rights in Canada and everything, and you want it for yourself. People everywhere have much bigger expectations around democracy and human rights than they used to have. Before, 20, 30 years ago, people in, well, even in many of your countries, you didn't know. 20 years ago, you didn't know much about the West or whatever. So globalization and then recognition as a human right also very important. Okay. Well, very quickly on this. So, another key driver is the rapid processes of democratic transition, basically post-revolution. So if you look at Eastern Central Europe, okay, all of these countries were communist and then moved basically to democratic system of government, and they were, freeing up the media, your countries, freeing up the media, making all of these kinds of changes. And these are the kinds of environments in which access to information has become adopted. Even in Africa, you have seen, lots and lots of one-party states. Now they have become more democratic. Latin America, hugely democratized. So a lot of sort of revolutions. The Middle East and North Africa. I'm spending 25% of my time in this part of the world, in Egypt, in Tunisia, in Morocco, in Jordan. I never used to go there. Now I'm there all the time because everybody's talking about right translation. As I mentioned, all of the countries in Eastern Central Europe have these laws. South Africa, Indonesia, revolutions. Now Myanmar, actually before I was here, I came from Myanmar. And I'm working there on media freeform access to information. Also, I would say a lot of support from the international community. So, a lot of countries in Europe, for example, they want to join the European Union, like Ukraine wants to join the European Union. As part of that process, they have to put in place access to information laws, and media freedom, etc., etc., etc. So pressure from, and now you can find 10 years ago, the World Bank didn't do anything on access to information, and now I work a lot with the World Bank. Most of the work I'm doing in MENA with the World Bank is on access to information. So you can see when organizations like the World Bank, it's not just UNDP and the development organizations, it's even the main financial institutions, okay, the organizations which drive the financial system of the world, when they start pushing access to information, changes the environment. And then civil society, of course, much. Okay. Actually, I'm going to go back to that and ask you, why, and now you're going to do some talking, why is access to information important? And in the beginning, you mentioned some ideas, but I want you to come up with some more ideas. What are the reasons why it's important? Yeah, go ahead. Are you looking to a career in the UN? I'm just saying.
To my mind, the main idea of the right access to public information is that people and citizens have the right to control the government. It seems to me that they are obliged to control the government.
Obliged to control the government. That's interesting. Well, maybe. Okay, so obviously, if we want to control the government, if we're going to exercise that democratic right, we need access to information. What are some of the other benefits?
Мне больше нравится идея о том, что для свободный обмен идей и государство должно создавать для этого делать условия, и это развивает чисто и экономики, и технику, и науку, и все, и общественные науки, и вообще как бы совершенствует государство. Прогресс человечества вообще происходит больше эффективно.
Okay, so it's good for business, good for the economy, good for science, good for a wide range of information-based activities in society. Very good. Other benefits. Yeah, 3 minutes left. If you want to be in the UN too.
Возможно, это важно для безопасности общества, его информированности о состоянии, о важных лицах, которых важно знать информацию об известных лицах. И обществу это важно знать об этих людях, об их состоянии здоровья, об их деятельности, о их нарушениях в своей деятельности, в сфере работы. Возможно, еще да.
Okay, so we need to know about the people that are running our country, something like that. Yes. Yeah, go ahead. You know, people on this side can also make comments. It's not only this side. You know, this is the right and this is the left.
Maybe I think it's like the core idea of civil society when there's a lot of NGOs which control government, and like the main idea is for each person to be able to take part in the state.
Yeah, absolutely. Participation, huge one. Anyone over this side want to say something? Want to suggest some ideas? You don't have to, but.
Once we take separate sectors of economy, we may also talk about public procurement. As far as it's clear and transparent and accountable, and the public information is all available online for users, we thereby attract investments.
Okay, I want you to push that a little bit further. Clear and accountable and transparent so that you avoid
Corruption.
Yes.
Here we go.
Anti-corruption. Absolutely.
We should also know how the public wealth property is redistributed. Therefore, we also need open registers, open information on tenders, on how the state and municipal property is distributed. This is also public interest. As for instance, residential place of our former USD President Yanukovych, this Mezigiria, was bought, you know, in a non-transparent way, and nobody disclosed actually purchasing contract. So there's a question whether there was a purchase at all.
Okay, so accountability in the whole financial sector to control corruption, but also in the sense of tenders to increase competitiveness and fairness in competition. Yes?
It's also about information of public interest. Something, for instance, may happen as emergency cases, as Chernobyl explosion, and all the information was given at that time, and it of highest public interest.
Sure. Definitely, that's true. That is reasonably, and not just for Ukraine, the whole world.
Or maybe something is spoiled at the canteen, board with someone in a non-transparent way.
Okay, so I think that you have gotten most of these democracy and participation, and not just, I mean, you talk a lot about controlling the government, of course, that's true, but also the idea that if more people participate in a decision, it's going to be a better decision, because it takes more perspectives into account. If the government sits in the office and makes the plan about development without talking to anybody, without collecting any ideas, without doing anything, it's not going to be a good plan. Because it doesn't have that many ideas. If you talk to the people, it's going to get better ideas. And also, when you come to implement, for example, those decisions, if people were involved in the decision, then they feel they belong to it, and they're going to participate in the implementation of that decision. Whereas if they can come down and they tell you, you have to do this now, without any discussion, then you think, oh, I don't want to do that. And you will resist it. So I think, getting ownership, accountability, good governance, advocacy, controlling government idea, better service delivery. Sometimes mistakes get made in services, not because of corruption and not because of some really wrong thing, but just because somebody forgets or somebody doesn't deliver the service. So openness helps with service delivery. Controlling corruption is one of the biggest stories of access to information. I'm going to tell you one story from Canada in a minute about corruption. Personal goals, accessing your own personal information and information that you want for personal reasons, and good for business. Good for business in the sense of fair competition, good for business in the sense of businesses using information. The government has a lot of information that businesses can use in productive ways. So using that information basically to make money. So there are hundreds of stories about access to information and corruption. I want to tell you one from Canada and see what you think. So I come from, Canada is about 35 million people, and I come from one small province which is only 1 million people. And it happens that the Minister of Defense comes from my province. And he's very popular in the province, but I don't like him. Anyway, he was Minister of Defense, and he went fishing. So Canada is a huge country, as you know, and he went fishing somewhere in the north. And when he finished fishing, he figured that he's the Minister of Defense. He's too important to waste his time driving back. He wanted to take a helicopter. So he phoned the search and rescue service. The service that exists if people get lost or, broken their car or whatever, or injured or attacked by a bear. This service that's for saving people. He called the search and rescue service and he said, please send me a helicopter, drive me back to the city. So the guy on the other end of the phone said something like this. Of course, if you ask this, we will send it. He's not going to refuse the Minister of Defense. He's a small official and the Minister of Defense, and the search and rescue is under defense, by the way. So he's the boss. He's not going to refuse it. But, sir, he continued, I would advise caution on this, because the use of, by ministers, of public transportation mechanisms is often the subject of access to information requests. So this is what he said to the minister. He didn't say to the minister, forget it, this is not your taxi, this is paid for by the people of Canada to perform an important public service. That is what he should have said. He should have said, forget it, I'm not driving you around. This taxi has, this helicopter is for a purpose, and it's not about you're having fun and saving you some time. He didn't say that. What he said is, watch out, we have access to information. Okay? And sure enough, 3 months later, somebody from the media made a request, all of the transportation the last 3 months by ministers on Air Force transportation, on planes or flying things or whatever. I don't know what the request is. But anyway, the media, they can't refuse to give this to the media. There's no anything secret about that, right? It's not giving exceptions. There's no sensitive information in this. The media, not only they found out that the minister had used a helicopter, but of course the telephone conversations in the search and rescue, they are all recorded, okay, because of the search and rescue service. The media got the exact statement made by the official on the front page of the newspaper, the exact quote from this official. So it shows the power of this thing. If everything is open and you can see everything, it's a pretty difficult to implement. What do you think about that story? It's a good story. It's a dumb Canadian story. You know, I told that story in the Philippines. I was talking about access to information in the Philippines. And they didn't seem to be very impressed with my story. So I said, you don't like the story? They said, oh, well, it's okay. They said, maybe in Canada. I said, but here the problem, the Minister of Defense steal the helicopter. All right. Recent trends. I'm going to skip this because we have more important things to cover. Okay. So now we're getting into what do these laws look like? What is supposed to be found inside of the access to information law? And here we can say that the access to information, a little bit like freedom of expression, which is derived from, you start with a broad presumption. All of everything is open, except for the exceptions. So it's a little bit like freedom of expression. Under international law, freedom of expression means all of expression is free, except the restrictions. So we start, you can say anything at all, and then of course we will limit it. So it's a little bit like that. And it should cover all information usually defined as recorded information. So we're talking, well actually this is being recorded. Okay, so this is being recorded by, I think, by that tape recorder. Yes, Igor? Being recorded? Yeah, okay, so this is recorded information. But if we go out in the corridor and we have a discussion, okay, it's not recorded. If we speak on a mobile phone, it's recorded. Okay, so recorded information is what's covered, and non-recorded information is not covered. Of course, very difficult to access non-recorded information. But otherwise, any information that communicates meaning, any information that is held by a public body. There was a case in Sweden quite a few years ago where somebody asked for the cookies on the Prime Minister's computer. Okay, the Prime Minister has a computer and they want to know what the cookies are. You know what the cookies are? It's the record of the browsing on the internet. So they considered the request and they decided that it was covered, it was information, it was recorded, it was held by a public body on the public computer, information was covered by the They looked on the computer and there were no cookies. So they told they gave the information to the requester, yes, there's no cookies on the Prime Minister's computer. Actually, it's quite interesting, public interest information, because the people of Sweden, then they know the Prime Minister doesn't use the internet. It's an interesting thing. So, but just to give a sense, in Canada, all of emails, BlackBerry Messenger, whatever it is, everything, mobile phone conversations, everything is covered. In principle, I mean, the practicalities can get a bit complicated. In terms of which bodies are covered, so the core idea is public bodies, but what is a public body? Oh, just to say, so I mentioned when I came in, we were having a huge conversation. I was at a conference here this morning, at a conference, a judicial conference, to discuss public information, scope of information covered under the Ukrainian law. And literally, I was listening to a 40-minute presentation by a judge going into precise analysis and detail of what is covered under the Ukrainian law. And I was thinking, this is really interesting, but how do you suppose that an official asked for information is going to understand that? I mean, it's, you could write a book, a legal book about this idea that he was talking about, The concepts about access to information, they need to be applied by officials. You ask an official for information, they decide, they give it or not. They need to have simple, clear concepts. So, all information is, if they have it, they give it. If they have it, it's covered. Okay, which bodies? So, all three branches of government. This is a human right. Human rights bind the state. They don't bind the government only. They don't bind only this or only that. They bind the whole of the state. They bind the courts. They bind the legislature. They bind the executive. They bind all levels of government, the national government, the municipal government, the whatever you have in your country. Any body that's created by the Constitution or created by law, automatically a public body, it's created by a public act. anybody that is owned, controlled, or funded by public bodies. So nowadays, it's very common for public bodies to push down jobs to other bodies. Often statutory bodies, but they may create a body to do something, so rather than doing it directly themselves. So anything that's owned, controlled, or funded, and even if the body undertakes a public function. For example, I don't know how it is in Ukraine or in your countries, but in my country now, the airports are not run by a public body, a formally public body. They're given to a private company to run it, and they run it in profit. It's not funded by government, they make profits. They're just like the toll road. Toll road is another example. A road is public function. And it's, you know, a road is a way to get from here to there, it's a public function. So public function is also covered. So broad in terms of information, broad in terms of anything that looks or smells like a public body, probably is. And in terms of who may make a request, in some countries, it's restricted only to citizens. I'm embarrassed to say, even in Canada, it's only citizens that can make a request. And this is something that we are fighting against all the time because it's ridiculous. It should be anyone. Human rights are protected to everyone, not just to your citizens. Okay. Any comments so far on that? This is international standards. I'm not saying that lost. But if you remember, the Ukrainian law did pretty well in terms of scope. In terms of scope, Ukraine got 28 out of 30. So, okay. The second out of a good law is. Wait, you're laughing at the first sentence? Yeah. No, it's absolutely true. So, the procedures for making a request and for processing a request and for responding to a request, lodging, processing, and responding, that's the machinery, the basic machinery or the engine which drives the access to information. I can give you examples where only one part of this was dysfunctional and the law died. In Thailand, they did not have any timelines. Okay? They didn't set a timeline, 30 days, 20 days, 10 days. They forgot it. So when the law was first passed, people started using it, and public bodies started to respond, and it was all going well, and everybody was happy. And then the public bodies realized, hang on a second, we have to respond. That's the law. It's our obligation to respond. But there's no time that we need to respond. We can respond in 1 year or 2 years or 3 years or 4 years. And that's what they did. They stopped responding. They basically stopped responding and the law died. Okay, so even one single thing feeds. In many countries, and fees here. In many countries, they put the fee up so high that kills it. Okay, if they don't have control, if the law doesn't control these things. So in terms of requests, how you can make a request, you can make it electronically, you can make it on a mobile phone, you can make it on a fax, whatever, how you can do it, what information you need to give when you make a request. Okay, it is very well established that you shouldn't have to give your reasons. The reason that you're making the request is not irrelevant to the public body. It's your right to get the information, whatever your reason. You don't have to have a reason. Assistance, if you're having trouble making the request, they should assist you. Reasons. Receipt, they should give you a receipt so you know the date, everything. And you shouldn't have to pay simply to make the request. Okay, that's just to put the request in. You're exercising a human right, you don't pay for human rights. Processing requests, timelines, transfers. You know, if the public body doesn't have the information, they transfer to another public body, and so on and so forth. Responding, form of information. So if you want the information in a printed form, like a copy, or you want it electronically, or you want to go into the public body and look through the document, for example, if you have a request and the response is a huge amount of information, you may not want to pay for the copies of that information. You want to go and look at it. There's only 3 things you want there, but you don't know which document it's in. So you go in, like you do research, if you're doing thesis, you go in there. Fees. So here is fees about making a request. Should be free to make the request. This is fees about getting the information. So good practice here, you can pay for the cost of photocopying, and if they mail you the information, you can pay for that, but that's it. No, there's anything. So, boring, but fundamental. All right, proactive disclosure, another important part of these laws. So, increasingly, public bodies in developed countries, at least, or in progressive countries, they're pushing out more and more information. In a country like Canada, to process a request takes quite a bit of time. They need to record the request, they enter it into a tracking system, they need to send a receipt, they need to go through the steps of responding to the request, blah, 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 blah. Okay, by the time it's all finished, they spend a lot of time. If they just put the document online, okay, I don't know, have any of you put document online? Yeah, you know, on Facebook or on whatever. It takes about 2 minutes, right? It's a much faster to put the document than to respond to a request. So it's more efficient to do proactive disclosure, and also it means that everyone can get the information. And imagine if you give the information because somebody requested, then another person requested, and you process the 2 requests instead of putting it online proactively. So there is a big move, basically, to put all of the information, not all, but a ton of information online. Also, as you probably know, and as I'm sure is happening in your countries, governments are increasingly moving towards e-government. So if I do everything online in Canada, I pay my taxes online, I pay my wife's parking tickets online. I'm supposed to laugh at my wife's parking tickets. I never get a parking ticket. I do everything I do with government, I do online. I don't interact with government officials at all. All of that requires a lot of proactive disclosure. So proactive disclosure, basically, the way of the future. And the really best systems for proactive disclosure happen like this. When a public official creates a document, okay, they're required to go through a little process where they fill in some details about that document, and when the document gets finalized, they push a button and it automatically goes on. So it's built, proactive disclosure is built into the creation of a document from the beginning. So some people call that RTI 2.0. All right, exceptions. All right, this is not boring. This is interesting. It's the opposite of procedures. Okay, so we all know that some information is open and some information is not. I already talked about my personal information, medical information, competitive information. Let's say I bid on a tender, I want to get a government contract, and I put in there sensitive information about how my company is going to deliver the product more cheaply than anyone else. Of course, I don't want my competitor to see this information about my business model. So there are a number of exceptions. The first issue on exceptions is how the access to information law should interact with secrecy laws. And in any country, if you look at the legal framework, there will be dozens, at least dozens, of secrecy rules. They're everywhere. They're in the banking law, they're in the privacy law, they're in the housing law. You know, you find secrecy provisions everywhere. Some of them going back, not hundreds of years, but maybe 100 years or something. I just came from Myanmar, as I mentioned. The day before I landed, some 5 journalists were put in jail for 10 years. Okay, that's a long time. Going to jail for journalists is already a crazy thing. For 10 years for breaching the Official Secrets Act. The date of the Official Secrets Act, 1923. It's a 91-year-old. So, I mean, you can imagine what kind of ridiculous British by the way, what kind of crazy thing. So in your country as well, you have some old, stupid laws. I'm sure nobody's updated to perfection. So how does the access to information law interact with those secrecy laws? Good practice is for the access to information law to override. In the case of conflict, anytime there's a conflict between the access law and the secrecy law, the access law will override. That's good practice. But it's still important to go through and revise the secrecy laws and to remove them or bring them into line. In terms of classification, okay, classification is, official put the stamp for official use only, secret, confidential, this classification? Yeah, so it is impossible, although it's possible in some countries, but it's impossible in theory for classification to trump openness. The law says you shall have access to information except blah, 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 blah. It cannot possibly be that when an official puts a stamp on a document, that makes it secret. If that were true, access to information are rubbish. Any official can put classification and kill his law. Okay, so it's not possible. Logically, it's not possible that classification can be access to information. But in some countries, they treat it like that, even though it's completely illogical. You cannot have an individual beating the law. Okay, the individual under the law. I used to work for the government of Canada for a couple of years at CEDA, and there, we would all classify, everybody was busy classifying documents. I don't know what the purpose of classifying them was. As soon as an access to information request come in, the classification clear out of it. Doesn't matter at all. When requests come in, whatever the thing on the document, you have to look at the exceptions in the law and decide it's covered or it's not covered. Okay, these three is basically, I'm sure you learned about the three-part test for restrictions on freedom of expression. So this is kind of three-part test for access to information. The first part of the test, the law should contain a list of the types of document that can be secret. And this list should refer to interests. Interests rather than categories of information. For example, privacy is an interest. Okay, I have my privacy, it's an interest to protect my privacy, and if you expose information, you can harm my privacy. National security is an interest. It's important to protect national security. Sometimes disclosure of information can harm national security. You tell the enemy your secrets, they can attack you, you're harming an interest. The armed forces is not an interest. It protects national security, that's an interest, but the armed forces is not an interest, it's a body. So information held by the armed forces should never be on such a list. National security is the interest that's relevant. Sometimes laws protect internal documents. This document's internal, we don't want to give it to you. Internal documents is not an interest. It's a category, it's a type of document. The list should never include types or categories, it should always include just interests. And linked to that is the idea that the information should be withheld, should be refused, only where the disclosure of the information would harm the interest. Okay, so for example, you might say that my email is private. Actually, it's not private because it's online. So disclosure of my email will not harm my privacy, so it should not be refused. There's a lot of discussion about this in the context of national security. I know that you're talking in Ukraine a lot about national security these days. If you think about national security, the United States have a lot of national security interests. They have a war in Iraq, a war in Afghanistan, blah, 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 blah. If you want to find out how much money the United States spends on military, you go online. All of this thing. You want to see quite a detailed breakdown of that information? All online. You want to know what kind of weapons the United States has? You go online. Okay, you know what kind of planes they have, what kind of tanks they have, what kind of guns they have. You want to know all that kind of stuff, you go online. You don't even have to make a request for information. And none of that harms their national security. Their national security based on the effectiveness of their machines, not how much people know about it. And so when you talk about harm, and this is where I think the biggest problem is in terms of failure of these laws. Many people just assume, because that information was always secret, there must be a reason that it was secret. So there must be a harm if we give it out. If you look, for example, at commercial contracts, in the most developed economies, all of the contracts between private business and the government is public. Not just public, but proactively public. They put them online. If there is some sensitive information in the contract, some small part of it, which will only ever be 1% or 2%, okay, just some of the business model, they can take that out. But the amount of the contract, the time frame for the contract, the deliverables of the contract, all of the details about it, the payment schedule, etc., all of that is public, and it is not harmful to commerce. It does not harm the commercial interests of the body that won the contract for all of that information to be public. Because they won the contract and now they're delivering it. So when it comes to harm, you really need to analyze in a clear way. Yes, it will actually be harmful if I get this information or not, and how it's going to harm the interest and whatever. Okay. Public interest override, even if the information will harm the interest, but the overall public interest is served by disclosure of information should still be disclosed. So, for example, you might have some sensitive military information, but inside of that information it shows that there was corruption, then you should always give out the information to expose the corruption. Exposing the corruption is more important public interest than protecting the national security. Okay, any questions on that? It's a little bit complicated, a little bit technical. If people are interested, I have documents that say a lot more about this. Oversight. So oversight is the appeals. So if you ask a public body for information and they refuse you, that's not the end of it. Obviously, if they can just decide whether or not to give you the information, you don't really have a right to information. In many countries, you have, the first appeal is an interim appeal. So you ask a higher authority within the same public body, the head of the public body, to review their decision. So they review the decision and they say, okay, we realize we made a mistake, we're going to give you the information. Some people, they see that just as being a waste of time. You already asked them, you have to spend some more time asking them again. But in practice, it can be quite useful because in many cases, the lower level official that dealt with the request in the first place didn't have the confidence to give out the information because they never did that before. They always protected information and never gave it. So especially at the beginning, it can be quite useful. Second level is administrative oversight to an independent administrative body. So, for example, in Ukraine, appeals go to the Ombudsman, Parliamentary Commissioner for Human Rights. This is very important. Third level is to the courts. This is very important because going to the courts is too expensive and takes too long for almost everybody just to get information. I have made a lot of information requests in my life, and sometimes I went to court as an NGO. But as a private person, I would never go to court just to get information. I'm going to spend 2 years and $10,000 to get information. I mean, I'm not going to do that. As an NGO, okay, I want to establish principles. It's my job to do that. So, administrative oversight for the vast majority of people, if this system works, that's what everybody uses. In Canada, we have an information commissioner, and about 1,500 appeals So every year, 1,500 appeals go to the Information Commissioner. From that, only about 10 cases per year go to the courts. So practically nothing is going to the courts. Okay, there are different models for this. It's getting a bit late, so I'm going to skip on a little bit here. In Ukraine, you have the system where you have an existing body, the ombudsman, and you added information to the task of the ombudsman. That ombudsman who already had a job, looking at relations between citizens and government, and you add some more to their job. That is a bad model, basically, a not effective model for a number of reasons. First of all, and this was really clearly demonstrated in the Ukrainian case, usually that body is more interested in the other part of their job than the access to information part. So, for example, when your law in Ukraine was adopted in 2011, the draft of the law had a lot of detail on the role of the ombudsman as the oversight body. Okay? Introduced directly into the law. The ombudsman reject that idea, and they said, no, we don't want that job because we already busy, we don't have enough time, we don't have enough money. So those provisions were actually removed from the law. So you can see, I mean, putting it to an existing body which has another job, usually they don't get much more money, usually they don't get much more resources, they're not that interested. The other problem, again, as represented in Ukraine, is in most cases, the body you give it to is the ombudsman, because that's the only body that you can give it to. Most ombudsmen don't have binding decision-making power. They make recommendations. So if you're dealing with electricity, you didn't get your electricity, then they talk to government, they say, this person didn't get their electricity, can you fix it? And the government says, sure, we'll fix it. Come on. You don't need binding powers for this kind of problems. When it comes to access for information, the government has refused you the information because they don't want to give it to you. They feel it's sensitive, they feel they don't want to give it to you. So asking them nicely, oh please get it, is not going to work. Okay, you need to have binding powers. So giving it to the existing body, it doesn't usually work. Better practice is to create a new body, an information commission, or you can call it whatever you want, and a lot of countries have that system. I will say that in Canada, again, our information commission does not have binding powers. But I think it's a little bit different, and I'm against that. I think that she should have binding powers. And when you talk to Natasha tomorrow, ask her about the binding power. She has a very interesting history with that. But she has binding powers. She has. She's not a commissioner. But in Canada, 97% of the time, the public bodies do comply with the recommendations of the commission. So that's a pretty high percentage. But I don't think in Ukraine, in Kazakhstan, in Belarus, in Russia, the compliance rate will be 97%. Okay? In your countries, government less max and want to comply with these decisions. Okay, so oversight. Okay, very quickly on this stuff. Independence. This body is like a quasi-judicial body. It's making adjudicative decisions. You're disagreeing with the government about something, and you're standing before it. It's a little bit like a court. The body has to be independent. Obvious. It is part of the government. It's not independent. It's not a proper decision. It needs powers. It needs to be able to investigate, and that should include, of course, it should be able to see any classified documents. So in Canada, for example, the Information Commissioner can get any document from any body. She can order the Secret Service to give her anything, and they cannot refuse. The Army, everything. That's a good model. Ask Natasha about that. Natasha's going to talk about this oversight thing, I think, in more detail. Obviously, the orders need to be both remedial, to give the information, and sometimes structural. So if the public body is failing to do the basic things it needs to do to comply with the law, sometimes you need to make structural decision. You need to say to an appointed information officer, train your officials to do something. Sanctions and protections. Okay, so sanctions are important if public officials obstruct, push back against access to information. It doesn't mean they made a mistake. They are actively pushing back against the information. And unfortunately, you find this in a lot of countries. Even in countries like Canada, you find officials, they don't like it, they don't want to give the information, they want to control the information, as we talked about from the beginning. If they push back, you need to have a way to sanction them. You need to punish them, and you need to do it once or twice to show them we're not going to tolerate this. And in many countries, you have criminal sanctions, but criminal sanctions are too heavy. You can't criminalize that kind of behavior. It's too much. What they did was wrong, but not that wrong. So administrative sanctions, I think, are a much better approach. You can fine them. Nobody likes to be fined. Okay, nobody likes the decision that they did a wrong thing, they have to pay a fine. That can be very effective. And in Ukraine, you have these administrative sanctions. Okay, it's also very important to have protections. We need to, if public officials disclose information in good faith, okay, they make a decision, you ask them for information, they apply the law, and they give the information, they need to be protected. They need to know that if they acted in good faith, they don't need to worry. They're protected against any sanction. Against any sanction under this law, against any sanction under any other law. If you don't give them that protection, they won't have the confidence to give the information. They're always worried about some other law. So very important to protect good faith disclosures under the law, and also better practice is to protect whistleblowers, so people that disclose information to expose wrongdoing. Can you think of a high-profile whistleblower these days that we're all talking about? Who's the most famous whistleblower today? Snowden. Yes. Edward Snowden. He's a major whistleblower. But Snowden is not in the United States, right? Yeah, he's in Russia. I know it's funny. He's in the. I think he's in the. Yeah, he's in Russia. So why is he not in the United States? Does the United States not have a whistleblower law? It has. So why is he not in the United States? It's always open. So he blew the whistle. He disclosed it. But he's still disclosing, right? You know, every week he disclosed some more information. Are you following? No. From time to time, he's not finished. He just started that. From time to time, he's giving up more. He has a lot of information somewhere. The reason he's not, well, one of the reasons he's not in the United States. In the United States, the whistleblower law does not protect people working for the Secret Service. He was working for the Secret Service, National Security Agency. He's not covered by the whistleblower. Yeah. But I think that even if he were covered by the whistleblower law, he's not going to the United States. You're not confident that he's going to be okay. Okay, and then you need a bunch of promotional measures. You need to appoint information officers. You need promotion. You need public awareness raising. If the public doesn't know about the law, they're not going to use it. You need training. You need reporting, so people know about what was done under the law. How the body should report how many cases they had, how many requests, what they did with them. And you need good record management, good systems for managing your records. If you can't find the information, you can't. Okay. And now, my last slide, you'll be pleased to hear some blue skies thinking. You know that term, blue skies? It means like thinking to the future. So the first blue skies thinking is 10 years ago, okay? So 10 years ago, 2004, almost nobody was, a few people, but almost nobody was talking about access to information as human rights. 15 years ago, really nobody was talking about access to information. Today, when I talk to groups like yours, they find it impossible that just 10 years ago, nobody was talking about this as a human right. It's so obvious it's a human right. In 10 years' time, they will think, how did we ever not think it was a human right? I mean, it was impossible. From Encyclopedia Britannica to the Internet. When I was a child, when I grew up, not that long ago, the very best information resource you could have at your home. You could go to the library, and the library was full of books, a lot of information. But at your own home, the very best information resource you could possibly have was the Encyclopedia Britannica. That was about 12 volumes, you know, of an encyclopedia talking about everything in the world. And if you look in the Encyclopedia Britannica, this is a 12-volume set, and you look under Ukraine, okay, maybe you will find 3 or 4 pages. Okay, that's it for Ukraine. All right, everything about Ukraine is 3 or 4 pages. When I was a child, we didn't have the Encyclopedia Britannica in my house because it was very expensive and my parents couldn't afford it. So we didn't even have that. 4 pages on Ukraine. But if I want to know about Ukraine, I have to go to the library. Not from my home, I couldn't do it. The other day, I have 3 children, 3 sons, and the other day I was sitting in my living room, and my children, very spoiled, they have their own laptop. You know, portable laptop. In my house, we have Wi-Fi, so they can get internet everywhere in the house. So I was sitting in the living room reading a book, and my son came in, and he's doing something on the computer. And after about 2 or 3 minutes, I could hear him getting, you know, frustrated and making some noises. So I said to him, "What's the problem?" I said, "I can't find what I wanted." So I said, "What are you looking for?" He was looking for information. I mentioned to you that I come from a small part of Canada with 1 million people. How many people in Ukraine? 35 million? 40 million? Yeah. So 1/40 of Ukraine. And he was looking for information about endangered bird species in Nova Scotia. Okay, it's about birds that are at risk of extinction in Nova Scotia. And he couldn't find it in 2 minutes, okay, and already he started to get frustrated and cross and whatever. Now, the first point is there is hundreds of pages of this information online. He's just too lazy to type enough words, okay? He typed bird Nova Scotia. You don't want to write endangered bird Nova Scotia, okay? So the reason he didn't find the information is because he's too lazy, not because the information is not there. But if you want to look at the difference, when I was a child, if we were rich, which we weren't, and we have the Encyclopedia Britannica, I can find 4 pages about Ukraine, and I feel very happy to get this 4 pages about Ukraine. He spends 2 minutes on his computer, and he feels frustrated that he cannot find out information about the most arcane and bizarre topic that you can't even think of. So, the difference in attitude about information, the difference in relationship about information from me to him, my attitude, so happy to get 4 pages on Ukraine, and I didn't get even. His attitude, any information I want it now, I want it bang, and I want it for free. He had a completely different attitude about information. So, what I think is that when he becomes a voter, okay, and when he is having to dictate and involve to government, the secrecy that we put up with, even the rules that I was talking about, the exception, the public interest, the blah, 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 when his generation, which is almost your generation, when they grow up, they are not going to tolerate this ridiculous level of government secrecy. They are going to insist absolutely to have all of the information, to have it for free, to have it when they want, and they expect government to be, their expectation of government on terms of openness, totally, radically much bigger than mine. Even I'm a campaigner for this issue than my expectations. So I'm looking forward to a period in 20 years' time when we are saying goodbye to ridiculous governments. All right, good. Thank you. I hope that you enjoyed that. Is there another slide? Yeah. So that's my my private email. Not private, actually. And this is my organization. If you go to the website of my organization, you will find a link to the RTR rating. If you're interested, a lot of information about access to information, freedom of expression, other things like that. And please feel free, if you're looking for information on these issues, and please feel free to email me directly. I'm not I don't mind about that. I hope you enjoyed it. I hope I didn't talk too much. It was you were too quiet. I tried to get you to talk more about this, and I'm going to be doing a couple more sessions with you on privacy or data protection and hate speech. So we'll see you again on Wednesday. With that.